All right, so we're on the record in docket 24-03376. That is People of the State of Michigan versus Gerald Dankenbring, I should say, Dankenbring. Will the parties please introduce themselves for the record? Mrs. L.
Thank you, Your Honor. Gabrielle Zell, Assistant Prosecutor for the People.
Ms. O'Brien.
Attorney Ina O'Brien on behalf of defendant Gerald Dankenbring, who's present and standing to my right, Your Honor.
And sir, you are Gerald Dankenbring, is that correct?
That's correct.
All right, thank you. This is the time set for a jury trial, and I was told that there was going to be adjourned. Mrs. L, how we proceeded?
Your Honor, that's my understanding as well. I believe the defense will be asking for an adjournment today as we are still awaiting a fulfillment of a FOIA request.
All right, Ms. O'Brien.
That is correct, Your Honor, and I do have for the court permission to approach.
Sure. Thank you.
Thank you, Your Honor. What I've handed you is the printout from my records center request that shows where we made a FOIA request for other incidences that are paramount, Your Honor, to the defense theory in this matter. There appear to be 6 incidences. We paid the $611.09 deposit back on March 5th. And as you can see, Your Honor, it just shows it in progress.
Okay.
We have done some brainstorming here on trying to figure out how this FOIA stuff works. I know that there's time restrictions, but it appears that the only time restrictions for them to comply was in the initial granting or denying of the request, where they had the 5 days and then the 10-day extension. But in terms of a time restriction regarding the actual fulfillment of the request, it's whenever they can.
All right.
Pretty much. So that's all I have, Your Honor. I really don't know when. It just shows it in progress. I pulled it up on the 21st. That's when I first brought it to the prosecutor's attention and the court's attention. I checked again last night. That's the one you have is my printout from last night.
All right.
That shows exactly the same thing as it showed back on the 21st.
All right. And Mrs. L, I mean, you might have to step in to see if you can expedite the matter.
She said she would.
Yeah.
Yes, Your Honor. I'm planning on going back to my office today to see what I can do about it.
All right. With that understanding, we'll adjourn the jury trial in regards to some pending discovery issues. And I'd rather set it later than earlier in order to make sure that this is all taken care of. We can set it and then reset it. That doesn't seem to make sense. We're looking at 3 or 6 weeks, right?
No, that was only on the ordinance side because of.
So what's our time frame?
Well, Your Honor, it's been the deposit was paid March 5th.
Okay.
We're
kind of waiting on the bureaucratic nature of when they say you can have it.
right. I have to assume that it's extensive because of the deposit being $611.
Right.
That's probably one of the higher FOIA deposits I've ever had to make.
Right.
However, then I have to get the stuff and then I need to send it. I've got to review it. Then I've got to send it to the prosecutor so they have their time to be able to review it.
So
I would say at least 6 weeks, Your Honor.
Yeah, I'd say 6. So what's our next jury trial date? And then the one after that?
Our next jury trial date is May 27th.
I think that's probably too close.
I think so, Your
Yeah,
Honor.
so let's
I'm
go to
gonna
the
be honest.
following one.
Just a
All right, let's pick it. We can pick a date and we'll make sure it's good for Miss O'Brien's schedule. That would be sometime in June, I think.
Yes. It looks like it would be June 24th at 8 a.m.
Does June 24th work with your schedule?
It does, Your Honor.
Right.
Thank you so much.
So let's go June 24th at 8 a.m. And then if either party needs a court order to make determination as to why we're getting caught up in this bureaucratic cycle, just bring it to my attention, okay?
I appreciate that, Your Honor. And again, the prosecutor did say that she was gonna see what she can do because my hands are tied. I've
Right.
done everything I can do.
Right, and it's been my experience, this isn't unusual. Every once in a while this happens. All right, so we've set it for June 24th at 8 o'clock for the pending discovery issues. I'll return the FOIA request to Ms. O'Brien. Anything else for the record in 24-03376, Mrs. L?
Not for the people.
Ms. O'Brien.
No, Your Honor. Thank you so
All right,
much.
thank you. We'll see everybody on June 24th.
Thank you, Your Honor.
Thank you. Right, Mrs. Zell, where are we heading next?
If we want to call the Blake Cornell case,
Cornell. Mr. Harris, how are you?
Morning, Your Honor. I'm doing good. How about yourself?
Pretty good. All right, so we're on the record in docket 25-00670. That is People of the State of Michigan versus Blake Cornell. Will the parties please introduce themselves for the record? Mrs. Zell.
thank you, Your Honor. Gabrielle Zell, Assistant Prosecutor for the People.
Mr. Harris.
Assistant Public Defender James Harris here on behalf of Mr. Cornell, who is joining via Zoom with court's permission, Your Honor.
And sir, you are Blake Cornell, is that correct?
Yes, Your Honor.
All right, thank you. This is the time set for, and you can hear me all right, Mr. Cornell?
Yes, I can, sir.
All right, thank you. This time is set for a final pretrial in the matter. Mrs. Zell, how are we proceeding?
Your Honor, at this time, the people have extended a plea offer to the defense through defense counsel. We are offering for defendant to plead guilty to count 1 of the operating while intoxicated. And we would be, my apologies, with an agreement to forfeit the weapon that was possessed at the time. Upon successful plea, we would be dropping count 2, possession of the weapon while intoxicated.
All right, and Mr. Harris, is that a fair and accurate statement of the offer?
That is a fair and accurate statement, Your Honor. I went over the offer with my client, and he indicated he would be accepting the offer at this time.
All right. So it'll be a plea to count 1. And there is a kilobrew of a forfeiture of the weapon. Upon a dismissal of count 2 upon successful pleading sentence of count 1. Is that correct?
Correct, Your Honor.
Mr. Cornell, is that your understanding? It is a plea to count 1, count 2 is to be dismissed, and there's an agreement between the attorneys that you forfeit the weapon that was involved in the event. Is that a fair and accurate statement?
Yes, that's a fair and accurate statement, Your Honor.
All right, Mr. Harris, we're on Zoom. I can take the plea and then we can set it up for sentencing. Is that how you prefer? Would you prefer to set this for plea?
My client has advised that he can report to probation within 48 hours, so we prefer to take the plea today.
All right. All right. So, Mr. Harris, may I inquire your client of his advice of misdemeanor rights on count 1?
Yes, Your Honor.
All right. Thank you. All right. So, Mr. Cornell, this is for bringing your attention to count 1, which is punishable by 93 days and or $100 to $200 fine and or 360 hours community service. You understand the nature of the misdemeanor you'd be pleading to, is that correct?
Yes, Your Honor.
All right. You have certain rights in this matter, and I'm going to walk you through those rights. You have the right to be tried by a jury, to be presumed innocent until proven guilty, have the prosecutor prove beyond reasonable doubt that you are guilty, to have witnesses against you appear at trial, the questioning witnesses are brought against you. You were represented today by Attorney James Harris, and he would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. Do you understand that, sir?
Yes, Your Honor.
You have the right to have the court order any witnesses appear in your defense, to remain silent during the trial, not to have that silence used against you, and to testify at trial if you choose to testify. If your plea is accepted, you'll give up the claim the plea was a result of any promises other than what we've stated on the record, or threats that it was not your choice to plead guilty. You'll also be giving up the right to appeal anything from trial. Since you won't be having a trial, you'll be pleading guilty to count 1 instead. Is it still your decision and your intent to plead guilty to count 1?
Yes, Your Honor.
Okay, I'm going to have you raise your right hand as best you can. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
I solemnly swear to tell the truth and nothing but the truth.
Okay. Thank you, sir. I'm going to bring your attention back to August 31st, 2023 at K North Road near Cedar Street in the city of Lansing, Ingham County. Were you operating a motor vehicle open to the general public on K North Road in the city of Lansing on August 31st, 2023?
Yes, Your Honor.
And at some point, did you find out that you were operating and you had a blood alcohol? At some point in time, did you come to find out that while you were operating, it is alleged that you had a alcohol content of over 0.08 grams under the influence of alcohol or intoxicating substance.
Yes, Your Honor.
And what did they say your blood alcohol was?
I particularly
Is this a
couldn't
combination?
remember. I think it was
0.131.
Okay, so you have no reason to dispute the allegation that was 0.13 at the time?
no, Your Honor.
All right. Anything towards a factual basis of Mrs. L?
No, Your Honor.
Mr. Harris?
Not from defense, Your Honor. Thank you.
Okay. I find the factual basis to be knowing, voluntarily, and accurately made. And we'll refer to probation. So Mr. Cornwell, you'll have 48 hours from today's date to come see probation. It's here on the 6th floor of City Hall. That's 124 West Michigan Avenue. That you should come to the 5th floor. It's on the 5th floor. And if you go all the way to your right after you get off the elevator, that's where probation is. You may want to call them to see, but it's within 48 hours because they'll either set up an appointment to prepare a report or they'll see you as you come. If you call, they'll just set up an appointment, I think. I'm not sure what their schedule is.
My understanding is they prefer people to come in person for that initial
Okay.
appointment so they can
All right.
prepare the pre-sentence questionnaire and paperwork. Your Honor.
All right, so Mr. Cornell, report to pretrial services, report to probation within 48 hours,
Yes, Your Honor.
and then we'll get a sentencing date. And the sentencing date will be
July 1st at 1:30.
July 1st at 1:30. What they'll do at part of the initial intake of probation within 48 hours is they'll start developing a report, and then we'll see what options are available to us on July 1st. All right, sir?
Yes, Your Honor.
Okay. Anything else for the record in docket 25-00670, Mrs. L?
Not for the people.
Mr. Harris?
Not from the defense, Your Honor. Thank
All right,
you.
Mr. Cornell, we'll see you on July 1st at 8:30 and report to pretrial services within 48 hours. All right, all right, sir?
Yes, Your Honor.
You're all set. Thank you for your appearance today.
All right. Thank you. You have a wonderful evening, sir.
You too. Mr. Stearman. All right, Ms. Provine, we'll call your case. So we're on the rec. Can I call these two files together, or do you want them separate?
Call them together.
All right, so we're on the record in docket 20-01888 and 23-00892. That is people of the state of Michigan versus Aaliyah Mervine. Will the parties please introduce themselves for the record? Mrs. Zell.
Thank you, Your Honor. Gabrielle Zell, Assistant Prosecutor for the people.
Mr. Lee.
Thank you, Your Honor. Assistant Public Defender John Lee on behalf of Aaliyah Helen Mervine.
And ma'am, you are Aaliyah Helen Mervine, is that correct?
Yes, Your Honor.
All right, and you can hear me all right, Ms. Mervine?
Yes, Your Honor.
All right, thank you. This is the time set for pretrial on both of these files. Mrs. Zell, how are we proceeding?
Your Honor, at this time, we're going to be asking for both of these to be set for a final pretrial.
And is that a fair statement, Mr. Lee?
Yes, it is, Your Honor.
So we'll set for final pretrial on both files. And that date will be
May 13th at 8:30.
May 13th at 8:30. May 13th at 8:30. All right, Ms. Mervine, we've set it for the final pretrial for May 13th at 8:30. Please keep in contact with your attorney, John Lee. Anything else for the record in 20-01888 or 23-00892, Mrs. Zell?
Not for the people.
Mr. Lee?
Nothing further. Thank you.
All right, we've set it for May 13th at 8:30. Thank you for your appearance today, ma'am.
Thank you, Your Honor.
Christina.
Then Mrs. Zell, Attorney Aaron Ogletree is here. And Attorney Sturdivant is here. I don't know if you needed to speak with them.
I don't for Sturdivant. I believe that was supposed to be a nollie, as long as the defendant took his plea in the felony case in Buchanan this morning.
Okay, and that's Michael Rich.
Felony pleas until 10:15 and we can't.
Oh, so that felony please at 10:15.
Okay, I guess we could call that then, and then I could file the nollie off the record.
Yeah, you can always follow an ollie.
Yeah. Okay.
So we can put it on the record and then wait for Denali.
Yeah, I think so.
All right, Mr. Sturdivant, we can call your case. And is Michael Richmond here?
He's zooming in from the jail, Your Honor.
I can barely hear you, Mr. Sturdivant. Let me see if I can raise this.
I'm sorry, he should be zooming
There
in
you
from
go.
the jail.
All right. So he should be zooming in from the jail. He's got a plea in front of Judge Buchanan, right?
Right.
My concern is if they bring him to us, they won't bring him for Buchanan.
Yeah, I'm afraid I have the same fears. If he's brought for us, then they won't bring him for his plea in Buchanan, or if they bring him in for his plea in Buchanan, we'll never see him. But my understanding, this is tied to the plea in Buchanan. Is that correct, Mr. Sturdivant?
Yes, my understanding is he's going to accept a plea offer and that filed to a misdemeanor with the eligibility or potential to petition for 7411 on that case because it's a possession down
All
to
right.
use of methamphetamine, and he's going to agree to pay the restitution on this file as part of that plea agreement. Otherwise, this case will be dismissed. So I'll log on to Judge Buchanan's at the appropriate time. And
But let's do this. We can put it on the record and wait the nollie process. And then if the prosecutor finds that this file is tied to that, let's put it on the record, and then she can enter in a nollie process to dismiss this file once she's secured that the plea went through.
that works for me.
All right, and we'll waive his appearance for purposes of this. I'm just afraid if we have him in this Zoom, he won't be put in Judge Buchanan's. That's my fear. All right, so we're on the record, and then that'll free you up to Mr. Sturdivant. So we're on the record in docket 24-02377. That is People of the State of Michigan versus Michael Richmond. Will the parties please introduce themselves for the record? Mrs. L.
Thank you, Your Honor. Gabrielle Zell, Assistant Prosecutor for the people.
Mr. Sturdivant.
Good morning, Honor. Daniel Sturdivant for Mr. Richmond, who is not with us today. I can waive his appearance on this, given the circumstances. I'm appearing via Zoom.
All right, and Mrs. L, you're willing to waive his appearance for purposes of placing this on the record, understanding he may be in another court.
Yes, Your Honor.
All right. So this is the time set for pretrial in the matter. Mrs. L, I'll let you make the record.
Thank you, Your Honor. At this time, there has been a plea offer extended in a felony file for Mr. Richmond. Based on that plea offer, this case would be dismissed with a promise to pay restitution once the plea and sentencing is complete in the felony file. It's my understanding that there is an intent to take that plea offer today in front of Judge Buchanan. And once that plea goes through, we would be filing a nollie in this case.
Do you have an amount as restitution?
I do, Your Honor. I can have one moment. It actually looks like, Your Honor, we are going to need to potentially ask for probation to determine the amount of restitution. Currently, it looks like the amount of restitution is about $2,471.
All right, and
I can
so
clear
that'll
that.
be determined.
I can clear that up for the court if I may.
All right, Mr. Sturdivant.
I believe Mrs. L has the total correct. For the record, it's $1,471.60 to Allstate. And
Alright.
then there is $1,000 to the homeowner. I don't really think we need to place her name on the record at this point, but it's two separate amounts for that total that Mrs. L stated. So that's my understanding of what the restitution amount is. Obviously, that will be placed on the record for the plea, but just so everything's clear on this file, that's what the restitution amount is based on my understanding.
Right, and is that your understanding, or that's a fair statement? That's the same amount?
It is, Your Honor. That's exactly how it's split up on my end as well.
So 2,471 to Allstate, and then an additional, or as a part of that?
1,000
Okay.
for
To the homeowner.
To Allstate, and then 1,000 to the homeowner, yes.
Perfect. And do we have a file on the on Buchanan's case? Just so I know.
It's 251065 FY.
So with a successful plea and sentence on that file and restitution ordered.
That might be Mr. Richmond.
I believe that is, yep, it is Mr. Richmond.
All right. And sir, are you Michael Richmond? Is that correct?
Yes, sir.
All right. And you can hear me all right, Mr. Richmond?
It's pretty loud, so it's like distorting.
All right. Well, what we're doing is we're making sure that we have your plea set with Mr. Sturdivant and Ms. Zell, indicating that you're going to plead in front of Judge Buchanan directly after this pretrial. Is that your understanding, sir?
Yes.
All right. We've got, and so outstanding restitution on this file, which would be part of the agreement, is the $2,471. And then the money is split between Allstate and the homeowner. And then this is a plea to Judge Buchanan's file, and on successful plea and sentence that restitution's ordered. Is that you? And then we will await the nollie pros from the prosecutor's office based on the plea in front of Judge Buchanan. Is that a fair statement, Mr. Sturdivant?
Yes, I think there's 60 cents on that number.
Oh, 60 cents. Okay.
Other than that, that's accurate.
All right. Is that your understanding, Mr. Richmond?
Yes, sir.
All right. So we will await the nollie pros to come in. So we're waiting the nollie pros from the prosecutor's office. And then Mr. Richmond, they should take you. You should be taken, or at least let them know you should be in front of Judge Buchanan for the I think it's a 10-15 plea. All right, sir.
Okay.
All right. Anything else for the record in 2402-377, Mrs. L?
Not for the people.
Mr. Sturdivant.
No, Your Honor. And if I could just have a brief breakout with my client once we're
Sure.
I would appreciate it. Thank you.
Sure. And then so we'll break out room, and then we'll make sure that at least email to make sure that they know that Mr. Richmond should be taken over for plea. And so I'll put you in room, so you'll be assigned to room 3, Mr. Sturdivant, and I will put post 1.
Excuse me, Your Honor, before you do that, could I be heard?
Sure. You can come on up.
Yeah, my apologies for interrupting, Your Honor. I have a vested interest in this matter. I'm supposed to be covering the plea hearing at 10:15 for Mr. Palmer on Mr. Richmond.
Okay.
And I was wanting to see if the court would allow, and if Mr. Sturdivant would have no objection, if I could be placed in a Zoom breakout room and speak to Mr. Richmond briefly on that matter.
Let's bring Mr. Sturdivant back because he's already in the room. And then Mr. Austin, we'll have you state your name and for the record, because I put him in and then he joined, and he should. All right, Mr. Sturdivant, Mr. Austin's here covering, he's going to cover the plea for Mr. Palmer in Judge Buchanan's courtroom. So just to explain all that, so Mr. Austin, you can make your record and indicate your appearance for the record.
Yes, thank you, Your Honor. Jared Austin from the Office of the Public Defender. I'm set to be covering the plea hearing with Judge Buchanan at 10:15 for Mr. Palmer, who is in another courtroom at the moment. And I was wanting to see if I could speak with Mr. Richmond briefly in a breakout room, if Mr. Sturdivant would have any objection to that or any objection to me joining him in that breakout room, just so I could talk to him about me covering that matter.
Right. So, Mr. Sturdivant, did you want to meet with Mr. Austin and Mr. Richmond in a breakout room so you can discuss some of the issues concerning the plea?
Yeah, that would probably be efficient, all in one
All right.
breakout room. Yeah.
All right. So once you join Mr. Austin, I'll put you in a breakout room with Mr. Sturdivant. Did you want the client in there too, Mr. Richmond?
Yes.
Okay.
Please.
All right. All right. So, Mr. Sturdivant, I'm going to move you. We're going to move you to room. We're moving you in and out here. We're going to move you to room 4. We're going to move Mr. Richmond to room 4.
Judge, if I may,
Yes.
Judge Buchanan did contact me this morning, and she does want Mr. Sturdivant at the police, so that was communicated to.
All right. So, and then Mr. Austin, when you join, and you can, I think they want Mr. Sturdivant at the plea.
That's fine, Your Honor.
All right.
I will be joining Zoom momentarily.
All right.
Thank you.
You're welcome. Here's Mr. Richmond. And then Megan, when Mr. Austin comes in, you can put him in room 4.
Okay.
I think it's room 4. That's right. That's where everybody's being put right now. So,
Good.
Mrs. L.
Could we call the Danielle Garreau case?
Absolutely. All right, so we're on the record in docket 25-00863. That is People of the State of Michigan versus Danielle Garreau. Will the parties please introduce themselves for the record? Mrs. L.
Thank you, Your Honor. Gabrielle Zell, Assistant Prosecutor for the people.
Mr. Doyle.
Thank you, Your Honor. Dan Doyle, appearing on behalf of Ms. Garreau.
This time set for a People of the State of Michigan free trial. Ms. Zell, how we proceed?
Your Honor, at this time, it's my understanding that the defendant has failed to appear today. The people would be inclined to ask for a bench warrant at this time, as this is an assaultive case.
All right, Mr. Doyle, and I know Mr. Doyle's been here since at least 8:30. So, Mr. Doyle, have you had any contact with Ms. Garreau?
No, Your Honor. This was a case I took on assignment for a conflict list. I've not had any contact with her through any available means.
All right, so this was scheduled for 9 o'clock. It is now 9:49. And I do not see Ms. Garreau in the Zoom courtroom or physical courtroom. And I've seen Mr. Doyle here for the last hour and a half, but I haven't seen Ms. Garreau. So we indicate that Ms. Garreau has failed to appear for the pretrial. And this is an assaultive crime. It's an assault and battery. Is that fair?
It is, Your Honor.
All right. So we'll issue a bench warrant and bond forfeiture. Anything else for the record in 25-00863, Mrs. L?
Not for the people.
Mr. Doyle?
No, Your Honor.
All right, thank you. Mr. Ogletree, did you want to speak with the assistant prosecutor on the case, or should we just call the case?
Yes, I
All
want
right.
to speak to her.
All right. So, Mr. Ogletree, I'm going to place you in room 2. And then when Mrs. L is able to join, I'll place her in room 2 also. All right, sir?
All right, thank you.
You're welcome.
Did Judge Buchanan send us somebody to take care of? I have no idea. She would probably have emailed Judge. You don't have your email up on the bench.
John Lee just reminded me that Slaughter is gonna be coming from MDOC, so I was wondering if them.
Who's here from Clark Hill?
That's what I'm trying to figure out.
I can ask.
Good morning, it's Mia Banks from Clark
Who,
Hill.
who is here from Clark Hill? You're under the moniker of Clark Hill, Washington Square.
Can you hear me, Your Honor?
And what's your name, ma'am?
Mia Banks.
She ended up.
Are you able to hear us?
Yeah, I don't have you on my docket, but you might be on Judge Buchanan's docket, but I don't have.
We're here for a 10 a.m. for Mr. Andrew Martin Mejia, Senior.
Oh, it's for the set aside conviction.
Oh. All right, I know you're on, are you on here for the, for Mr. Mejia?
Yes, sir.
All right. All right, I now know your file and I have it. So give me a couple minutes. The assistant prosecutor is going to be in a breakout room and then we'll call your case, all right?
Thank you so
And
much.
I just recognize you, you're Miss Banks.
Yes.
Yes, I remember you.
Good to see you, Your
All
Honor.
right, so I'll call your case in a few minutes.
All right, thank you.
Thank you. Yes. All right. Yes. All right. All right. Yeah. Yes. Yes. Yes, not, yeah, correct. Mm. Yeah.
All right. All right. All right. Talk to you Friday. Yeah. Yeah. Bye.
Can I be placed in the breakout room, Mr. Keegan?
I'm sorry, what was that?
Can I be placed in the breakout room for my client, Mr. Keegan? Or I'll give you a call, Mr. Keegan, one moment.
Okay.
That is People of the State of Michigan versus Martise Gill. Will the parties please introduce themselves for the record? Mrs. Zell.
Thank you, Your Honor. Gabrielle Zell, Assistant Prosecutor for the People.
Mr. Harries.
Assistant Public Defender James Harris here on behalf of Mr. Gill, who is standing to my right, Your Honor.
And sir, you are Martise Traquan Gill, is that correct? Thank you. This is the time set for a pretrial in the matter. Mrs. Zell, how are we proceeding?
Your Honor, at this time, I have been in contact with the complaining witness in this case, and they have indicated that they do not want to proceed on this file. At this time, we are unable to move forward without them, and we would be requesting a nollie to be filed in this on our own motion.
And do you have any record you want to make? I'm assuming you don't have an objection to the nollie process, Mr. Harris.
And we do not have an objection to the nollie process. I would simply request my client be given a copy of that.
All right. All right, I'm in possession of the nollie process or order of dismissal on 25-00980, signed by the prosecutor pursuant to the nollie process. I will sign the document. So this case is dismissed without prejudice, which means the people could reissue if they choose to. It's kind of the default, but for our cases, for our purposes today, the case is dismissed. And Mr. Gill, you can get a copy of the order from my court officer. All right, sir. Anything else for the record in 25-00980, Ms. Zell?
Not for the people.
Mr. Harris.
Not from the defense, Your Honor.
All right, you're all set, sir. Thank you for your appearance today.
Thank you. Anything happened to this case that you or like and it's taken
Do you want to speak to him again?
Nope.
Okay.
And then Ms. Zell, what do you want to call next? And Mr. Ogletree is still in room 2. Should I bring him over to the main room?
If he could speak to his client, if
Okay.
we could instruct his client to go or
All
send his
right.
client to that.
So
room.
that's Mr. Keegan. All right. So Mr. Mubray, I'm going to put you in a breakout room with your attorney. All right, sir?
I've already spoke with my attorney.
So
Ogletree asked for him to
All right.
speak again because an offer has been extended.
All
to
right.
his room.
So Mr. Mowbray, your attorney's asked to speak with you again. So I'm going to place you in a room with him, and then we'll come back and place it on the record.
Okay, thank you.
You're welcome. So room 2. So you should get a prompt to go to room 2, and there you can see your lawyer. All right. In what case are we calling next, Mrs. Zell?
Could we
And
call?
we also have Mr. Mejia here on both those set asides.
Okay.
Just so you know,
I appreciate that.
it's at 10 o'clock.
Okay, can we do the slaughter case, please? It's a terrible thing.
Which case is that?
Philando slaughter, it seems to be 18-04781.
Oh, I see it. It's kind of hidden in there. It is right before De Leon is Philando slaughter 1-8. And I have the file.
Oh,
It's underneath all the.
Yeah, it's kind of
Scott keys.
right before.
thank you. I was not seeing it.
And Mr. Ogletree, did you have the opportunity to speak with your client? I can bring him back if you choose. All right.
We're ready, Your Honor.
All right. I'm going to bring him back. So and then we'll go on Mr. Slaughter's case. So we're on the record in docket 1804781. That's People of the State of Michigan versus Philando Slaughter. Will the parties please introduce themselves for the record? Mrs. L.
Thank you, Your Honor. Gabrielle Zell, Assistant Prosecutor for the people.
Mr. Lee.
Thank you, Your Honor. Assistant Public Defender John Lee appearing on behalf of Philando Slaughter.
He's joining us by Polycom?
Yes.
And sir, you are Philando Slaughter, is that correct?
Yes, sir, that's correct. Good morning, sir.
All right, you can hear me all right, Mr. Slaughter?
Yes, sir, I can.
All right, thank you. This is the time set for a pretrial on the matter. Mrs. L, how are we proceeding?
Your Honor, at this time, a plea offer has been extended to the defendant through defense counsel. The offer is currently to plead to an added count 2 of retail fraud third. Upon successful plea, it would be a dismissal of count 1, the retail fraud second. Additionally, Your Honor, there is a Killebrew agreement for time served.
All right, so this would be a added count 2 of retail fraud in the third degree. Retail fraud in the second degree is to be dismissed. And do we have a notion of what the time served, how many days that is?
I am not certain, Your Honor. He has been in MDOC for the past year. He's
Okay.
anticipated to be there for at least another 3 months.
Okay. What do we have in there? I have he was arraigned as of and PR'd as of April 4th was the date of arraignment.
So technically, he has no time on this case because
And we know he's going to be in DOC for, all right, yeah. All right, so that is a plea to retail fraud, third retail fraud, and the second is to be dismissed. And there's a Killebrew agreement of time served. Is that a fair statement, Mrs. L?
It is, Your Honor.
Mr. Lee?
Yes, Your Honor.
All right. May I inquire of and Mr. Slaughter, that's your understanding of the plea agreement, a plea to count 2, the misdemeanor is punishable by 90 days and or what's the amount on that, on the retail fraud? 500? So that's your understanding. You'll be pleading guilty to the retail fraud in the third degree, which is punishable by 90 days and or $500. There is an agreement between the attorney that you get any time would be time served. Do you understand that, sir?
Yes, sir.
Okay. May I inquire of your client of his advice, misdemeanor rights on the retail fraud third, Mr. Lee?
Yes, you may, Your Honor.
All right. Mr. Slaughter, you understand you have the following rights on this retail fraud in the third degree plea, and I'll walk you through those. You have the right to be tried by a jury, to be presumed innocent until proven guilty, to have the prosecutor prove beyond reasonable doubt that you are guilty, to have witnesses against you appear at trial, to question the witnesses that are brought against you. You are represented today by Attorney John Lee, and he would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. Do you understand that, sir?
Yes, sir.
You have the right to have the court ordering witnesses appear in your defense, remain silent during the trial, not to have that silence used against you, and to testify at trial if you choose to testify. If your plea is accepted, you'll give up the claim the plea was a result of any promises other than what's been stated on the record or threats that it was not your choice to plead guilty. You'd also be giving up the right to appeal anything from trial. Since you won't be having a trial, you'll be pleading guilty to the retail fraud in the third degree instead. Is it still your wish to plead guilty to the retail fraud in the third degree?
Yes, sir.
All right. I'm going to have you raise your right hand as best you can. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes, sir. Yes, sir.
I'm going to bring your attention back to September 17th of 2017 at 3131 East Michigan in the city of Lansing, Ingham County. Were you at the Sears store on East Michigan in the city of Lansing on September 17th, 2017?
Yes, sir.
And at that time, was Sears open to the public, selling property to the public?
Yes, sir.
And did you take items that you did not pay for from Sears under the price of $200?
Yes, sir.
And you knew they were being offered for sale by Sears at the time you took them and you didn't pay for them?
Yes, sir.
Anything towards a factual basis of Ms. Azell?
No, Your Honor.
Mr. Lee?
Nothing further.
Okay, I find the factual basis to be knowing, voluntarily, and accurately made pursuant to the circumstances. Mrs. L, do you have any preference in regards to immediate sentencing?
I have no preference, Your Honor.
Mr. Lee?
Prefer immediate.
All right. So we'll go to immediate sentencing on the matter. Allocution, Mr. Lee.
Your Honor, when I spoke with Mr. Slaughter, he expressed to me that he is a changed man. He is a preacher in the prison. He sings in the choir and he wants to mentor youth when he gets out. He given options. He chose to take responsibility for this matter, and we would just ask the court to consider that in sentencing.
All right, Mr. Slaughter, is there anything you'd like to say to the court before the court passes sentence?
Yes, sir. I apologize for the inconvenience of, having myself in that situation. I apologize for the courts, and the people that, I harmed in the process of, betraying their trust. Like the lawyer, Mr. Lee said that, I am a changed man, by the grace of God. So you'll never have to worry about seeing me, in your courtroom or any other courtroom again. So with that being said, I thank you for this opportunity to be able to finally get this behind me and start, a new life, with giving back to society out there from the things that I took so much from. So, that's it, sir.
All right. Thank you, Mr. Slaughter. Mrs. Ells, is there anything you'd like to say before the court passes sentence?
No, Your Honor, we'll leave it to your discretion.
All right. I will set sentencing at time served on the 2017 case. And then this actually for events that happened on September 17, 2017. I'm going to waive any fines and costs. And I'm going to waive any crime victims' rights fee or state fee. So, Mr. Slaughter, so that should dispose of this case, this retail fraud in the third degree. So, Mr. Slaughter, when you get out, you can start fresh, and you won't have this case you won't have anything in regard to this case to tie up any ends. You should be all set. All right, sir?
Yes, sir. Thank you, sir. I really do appreciate you.
All right. You're all set. Thank you for your appearance today. We're all set in 1804781. Thank you,
Yes,
Mr.
sir.
Slaughter.
Thank you, sir. Have a great day.
You too. Then, Mrs. L, did you want to go on Ogletree?
Yes, Your Honor, I'm ready.
Keegan? Ray? Yeah, I don't. All right, Mr. Ogletree, we'll call your case with Mr. Mubray. So we're on the record in docket 2500786. That is People of the State of Michigan versus Keegan Mubray. Will the parties please introduce themselves for the record? Mrs. L.
Thank you, Your Honor. Gabrielle Zell, Assistant Prosecutor for the people.
Mr. Ogletree.
Aaron Ogletree on behalf of Keegan McRae.
And sir, you are Keegan Mubray, is that correct?
Yes, Your Honor.
And you can hear me all right, Mr. Mubray?
Yes.
All right, thank you. This is the time set for pretrial in the matter. Mrs. L, how are we proceeding?
Your Honor, at this time, a plea offer has been extended to the defense through defense counsel. That plea offer would be to plea as charged with an agreement to 7694A. I will defer to Mr. Ogletree to see how we are proceeding.
All right. So the agreement between the lawyers is a killer brute 769-4A status. Is that correct?
It is, Your Honor. I'm not sure that this will be accepted at this time, but I wanted to place the offer on the record.
All right. Mr. Ogletree.
Here's special requesting a final pretrial date.
All right. So we'll set for final pretrial. For
May 13th.
May 13th at 8:30. It's a domestic violence case, so they'll be live in person on the 6th floor of City Hall of Lansing. At 8:30 on May 13th.
Your Honor, is it possible to do the 14th? Because I have two other bench trials in another jurisdiction on the 13th.
Let's see if we can. let's see if we can find a date that works on that final pretrial date for your schedule, Mr. Ogletree. Since it appears you have a conflict.
Or if I can appear by Zoom.
Or that's really up to Ms. Zell. Would you, it's your preference to, we can either move the date or we can appear by Zoom.
I would prefer if we could move, Your Honor.
Okay.
May 20th.
How does May 20th at 8 work for your schedule?
8:30.
It'd
Yeah,
be
that's fine.
8:30.
May 20th.
Okay. All right, so May 20th at 8:30. We'll be live in person on the 6th floor of Lansing. That's an 8:30 at 8:30. Anything else for the record? So Mr. Moubre, we'll see you on May 20th at 8:30.
Yeah.
Anything else for the record?
And
Go ahead,
one of
Mr.
the things that we were requesting, if his bond could be modified in terms of right now, he can't, he's not able to reside in his apartment building. We wanted to know if he could be able to reside back there. My understanding, the complainant used to live in the same complex, but not the same apartment building. Want to know if that could be changed, because it's causing hardship. He now has to reside with his sister.
So going back to the Long Boulevard address will not put him in violation of the no contact order. Is that my understanding?
That's my understanding. My understanding is the complainant resided in a townhome, and he resided in an apartment building.
All right, so I'm going to confirm the address or update the address, and that's what the arraigning magistrate indicated, that must provide valid release and address. So that would be the good address, would be confirming the 900 or the Long Boulevard apartment address. Is that correct?
To my understanding, yes.
And then going back to that address will not put him in violation of the no contact order. Is that a fair statement, Mr. Ogletree?
That's my understanding.
And Mr. Moubre, that's your understanding, that going back to that address will not put you in violation of the no contact order with a Carmen Hargrove. Is that correct?
Correct.
All right. So that's just a clarification of the no contact order. I don't think that's a modification, because it doesn't place him in violation of the no contact order. Any comment on that, Mrs. Zell?
Your Honor, I just don't have any confirmation that Ms. Hargrove has moved out of those apartments. I can try to get that. I wouldn't have any issue with that as long as the actual no contact stays in place.
All right. So there's currently still a no contact order with Carmen Hargrove, and so Mr. Moubre understands that's an order from pretrial services. That's an order out of arraignment. Whether Ms. Hargrove wants that to be in place or not, that's the order. There's a no contact order. The only thing that trumps that is another order from the court. It's not any indication from Ms. Hargrove that order should be set aside. So you understand that, Mr. Moubre?
Absolutely, Your Honor.
All right. All right. With that understanding, no contact order is in place, and going back to the address will not put him in violation of the no contact order. So with that clarification as to the no contact order, I don't think I have to modify the order. I'll just clarify it. Anything else for the record in 25-00786 of Mr. Ogletree?
No, Your Honor.
All right. All right, Mr. Moubre, we'll see you on May 20th at 8:30. Thank you for your appearance today.
Thank you, Your Honor. Have a good day.
You too. Now what happened to that? How weird. All right, Ms. Banks, we'll call it Mr. Mejia's case. We had some technical difficulties, kind of. So we're on the record in the docket C2303495 and C300294. These are motions to set aside conviction. Appearances to the record, Mrs. L.
Thank you, Your Honor. Gabrielle Zell, Assistant Prosecutor for the people.
Ms. Banks.
Good morning, Your Honor. Amia Banks Clark Hill on behalf of Mr. Andrew Martin Mejia Sr.
And sir, you are Andrew Mejia, is that correct?
Yes, sir.
Okay, and you can hear me all right, Mr. Mejia?
Yes.
Right, this is the time set on a motion for application to set aside the conviction on 2 files. And I just had the motion and I don't know what I did with it.
It should be attached as Exhibit F to the brief submitted to the court.
That is, yes. I had a separate motion but I can use that one. All right. So I am in possession of the brief submitted to the court on behalf of Mr. Mejia. I'm also in possession of 2 letters from the Attorney General from Michael Ajani dated February 27, 2025 on docket C203495 and C300294, indicating they have no objection to the court granting the application concerning these post-conviction circumstances. And that is consistent with the welfare of the parties to grant the conviction. I've indicated if Mrs. Zell has any objection to the motion And Mrs. L, any objection to the motion from the prosecutor's office?
No objection, Your Honor.
All right. So Ms. Banks, any argument in favor of the motion? Considering that it appears there's no objection to the motion.
Just that it's been 32 years since Mr. Mejia's convictions. He has changed his life. He's clean and sober. We believe the justice system did exactly what it's intended to do and helped rehabilitate Mr. Mejia. We believe that the convictions are eligible for expungement. It has been longer than the required 5 years since those convictions. And Mr. Mejia's behavior since that time indicates that he is ready to fully reintegrate into society and put these convictions behind him.
All right, thank you, Ms. Banks. So I'm going to rule on the motion on order on application to set aside concerning an aggravated assault out of February 24th, 1993, and an aggravated assault out of February 24th, 1993. It is indicated on the order of the application to set aside that the application has not been convicted of more than 3 felonies. The applicant has had no convictions since the 1993 event. There are not criminal charges pending. The time period required by 780.621 has passed as indicated by counsel. I'll indicate that an opportunity has been given to the Attorney General and the prosecuting official to contest the application and circumstances and behavior of the applicant from the date of the applicant's conviction to the filing of the application warrant, setting aside the conviction and consistent with the public welfare. I'm going to grant the motion under box 15 so I'll grant the order to set aside both aggravated assaults out of 1993 in regard to 750.81A. And just for clarification, that is docket C203495. And then also grant the order to set aside the conviction out of 1993, that's C300294. I will sign the order accordingly with today's date. And we should be all set. Anything else for the record in C203495 or C300295? Ms. Banks, on behalf of your client.
No, Your Honor. Thank you so much.
All right, Mr. Mejia, good luck to you. You should be all set. Ms. Banks, it was nice to see you.
Nice to see you as well, Your Honor.
All right, thank you. Thank you both. 25-01004. That's people of the state of Michigan versus Christopher Hill. Will the parties please introduce themselves for the record? Mrs. L.
Thank you, Your Honor. Gabrielle Izella, Assistant Prosecutor for the people.
Mr. Lee.
Assistant Public Defender John Lee appearing on behalf of Christopher Stephen Hill.
And sir, you are Christopher Hill, is that correct?
Yes, sir.
All right, and you can hear me all right, Mr. Hill?
Yes, I can.
All right, thank you. This is the time set for a pretrial in the matter. Mrs. L, how are we proceeding?
Your Honor, at this time, we're going to be asking for this to be set for a final pretrial.
All right, is that a fair statement, Mr. Lee?
Yes, it is, Your
All
Honor.
right, we'll set for final pretrial on
Excuse me, May 13th at 8:30.
May 13th at 8:30. And that'll be live in person on the 6th floor City Hall of Lansing on 124 West Michigan Avenue. Will be on the 6th floor, May 13th at 8:30. Anything else for the record in 25-01004, Mrs. L?
Not for the people.
Mr. Lee.
No, Your Honor, thank you.
All right, Mr. Hill, we'll see you on that May 13th date. Thank you for your appearance today.
No problem.
It is warm in here.
I don't think it was that warm outside either.
Right, well, it's warmer in here.
It's like in the 70s or 80s outside. Is it?
It was 71 when I
Is it?
when I left home at 6:15.
Because it was warm last night. It's still warmer, you know.
Yeah, warm and windy.
Yep. It was windy yesterday.
That's been making
Which
me tired.
in April, we're not used to this type of warmth. So come June, July, if it gets really hot in here, I felt bad for Abigail would get hot. You could tell.
Sarah Donnelly.
Yeah, Sarah Donnelly would get really hot.
Yeah.
You know, and I don't feel it too much, but we'd have to turn that off for testimony. And then it gets, then I'm turning on the fan under the table and everybody's sweating and, you know, you're allowed to, as long as you ask, you're allowed to take your coat off because, you know, everybody's hot.
We've got a couple profers that
Did not appear?
Yeah,
All right.
if you feel like calling them.
And then we have a De Leon friend. It's Francisco De Leon.
Yes.
Let's call that last.
And then on that case as well, the victim is here today. She is requesting the no contact order be lifted. That's why she is present today. She does speak Spanish and I failed to get a translator as we had our conversation yesterday at 3 p.m.
All right. And is Francisco De Leon here?
Yes, yes,
Yes,
Mr.
he-
Harries is out speaking with him.
And
there's an interpreter as well. There is an interpreter.
There's an interpreter for him.
For the defendant. I failed to get one for our.
But you feel comfortable with the lifting of the contact order at the request of the victim. You've had that conversation.
Yes,
Okay.
I think it would be completely fine in
Okay.
this situation.
All right. Do you want to start with Shab and work there, or do you want to do that first?
We can do shop and then work our way down,
Okay.
because I don't know.
I think
how-
James is still talking to him, isn't he?
Yeah,
All right.
but sometimes there needs to be a punch.
Let's do Shab.
Everyone gets that way.
Oh, but James is still on Shab, right? He's on the last one.
No. He, Shab originally applied for and was approved for the defender's office, but then decided he wanted to represent himself.
Okay.
It's
So
my
let's,
understanding.
all right.
We are.
All right, so they're not representing him, so we can go forward. All right, so we're on the record in docket 22-02821, 22-02822. Might as well open these and 821, 22-02822. 22-02823. 22-02824. And 22-02825. That is people of the state of Michigan versus Randolph Leash Schaub. Parties appearances for the record, Mrs. L.
Thank you, Your Honor. Gabrielle Izell, Assistant Prosecutor for the people.
All right, this is the time. This was set for 8:30 for a final pretrial. It is now 10:50. it would appear that Mr. Schaub has not appeared today for any of the files for the final pretrial. There's nobody by the name in the Zoom courtroom, nobody by the physical courtroom, and the hallway's been broached several times. Mr. Schaub is not in the hallway. It would appear that the defendant has failed to appear for the final pretrial. I do have, it was set on April 1st. Let me see if I have any failed to appears. I don't have any on my files.
He failed to appear on 12/02/22 for pretrial.
Not on any of these files.
22/02/81.
Yeah, not on. So 22/02/821 or 81, because we have 22/02/821.
Yeah, that's what I'm looking at. It says he failed to appear on 12/2. And a warrant was issued.
Oh, that
would make sense because they're all 2022 tickets. So
yeah, I've got a fail to appear on October 7th. Yeah. All
I
right.
just say he's backed up.
All right. So the defendant failed to appear and has a previous fail to appear on at least all of these files someplace. 22/02/824 on November 28th, 2024, November 28th, defendant failed to appear. And then he's been arraigned on multiple times. Mrs. L, how did you want to proceed?
Your Honor, at this time, we would ask for a bench warrant to be issued in this case.
All right, so I will issue for the defendants failed to appear a bench warrant and bond forfeiture. On file 22/02/825, 22/02/824, 22/02/823, Twenty-two zero two 22/02/822, and 22/02/821. Bench warrant and bond forfeiture issued on each one of those files. Anything else for the record on any one of those files, Mrs. L?
No, Your Honor.
You should be all set. Thank you for your appearance on those. So those are all the shop files. We'll get 5 bench warrants on those. All right, so we're on the record in docket 23/01/214 and 23/02/101/215. That is People of the State of Michigan versus Charlena Sims. Appearances for the record, Mrs. L.
Thank you, Your Honor. Gabrielle Zell, Assistant Prosecutor for the People.
Okay, this was initially scheduled for pretrial at 9 o'clock. It is now 10:54. It would appear that the defendant has failed to appear for the pretrial. I do not see Charlena Sims in the Zoom courtroom, physical courtroom, and she's not made her name known in the hallway. It would appear that the defendant has failed to appear for pretrial. This one, I have a failed to appear at arraignment, which was mailed, but I don't have any failed to appear for court. Does that match up with your file, Ms. Zell?
It does for as much as of the file as I can see, Your
All
Honor.
right.
Since the ticket case, our filing system's a little wonky.
Okay. Yeah, so How did you want to proceed, Mrs. L?
Your Honor, at this time, I think I would just ask for a courtesy reset. This is not an assaulted case. It is a dog license case. I would honestly like the opportunity to do a little research myself to make sure this is still a viable case.
Yeah, the claim at arraignment was she never got notice, and that's why she failed to appear for arraignment. It's either that or a bench went with a 48-hour hold, and I will honor the request for a reschedule to see the viability of this case. And we'll reschedule for
Let's do May 29th at 9.
May 29th at 9 for file 23-01215 and May 29th at 9 for 23-01214. Anything else for the record in either one of these files, Mrs. L?
Not for the people.
All right, we should be all set on those.
It also says she requested CAA and there is no comment about it.
There's no follow-up on that.
Doesn't look like it, so I will send
All
an
right.
email.
Yeah, send an email.
It's fine, those when you have a chance.
All right. These are the warrants for Shab.
They are.
Sarah Whitman said you were during the conference.
Great, yeah.
You want to go on US De Leon?
Yes, we are ready on Mr. Ustelion.
Okay. And then we'll do all of the Scott files.
Yes.
All right, so we're on the record in docket 2501-031. That is people of the state of Michigan versus Francisco US De Leon. Will the parties please introduce themselves for the record? Mrs. L.
Thank you, Your Honor. Gabrielle Izell, Assistant Prosecutor for the people.
We have a translator, so let me swear that in. That completely slipped my mind. So, sir, please state your first name and last name and spell them both for the record.
First name Jorge, last name Bufurno, JORGE-DIFURNO.
All right, thank you, sir. I'm going to have you raise your right hand. Do you solemnly swear or affirm that you will truly, accurately, and impartially interpret in the matter now before the court and not divulge confidential communications? So if you got under the penalty of perjury. All right, thank you. You just let me go. You let me know if I get going a little fast. All right. All right. All right. So we're on the record in 2501-031. And then Mrs. L, your appearance for the record.
Thank you, Your Honor. Gabrielle Izell, Assistant Prosecutor for the people.
Mr. Harris.
Assistant Public Defender James Harris here on behalf of Mr. Ustelion.
And sir, you are Francisco De Leon, is that correct? Yes. Thank you. This is the time set for pretrial. And Mrs. L, how we proceed?
At this time, Your Honor, a plea agreement has been extended to the defense. It would be a plea to count 1, domestic violence, with a Killebrew agreement to no upfront jail and 7694A status. Additionally, we would be denying a case that has been referred to our office and is currently in screening with us.
Killebrew, no upfront jail. 769 4A status. And the denying of a pending warrant.
Correct, Your Honor.
That is correct, Your Honor. I have spoken with my client. And he has indicated that he will be accepting that offer. We will be requesting the court to handle a no contest plea today.
Okay. So we'll need a factual basis to be emailed to Wendy or Megan for the no contest plea, unless you have another factual basis. She has it?
Is that it? That's it then.
Okay.
Yes, Your Honor, I forwarded a copy of the police report with the relevant sections highlighted for the no contest.
It's a
plea.
no contest to count one.
Yes, and the reason for the no contest plea is a lack of memory due to intoxication.
Judge. Would you tell me to print certain pages? You didn't realize it was 10 pages.
It's 2 pages I've got.
That's Ms. Holden.
Okay, you did
Yeah.
get it, okay.
No.
I wanted to make sure. None of mine are how my computer.
All right, so Mr. Harris may inquire of Mr. Leon of his misdemeanor rights.
Yes,
So-
Your Honor.
All right. All right, so my understanding is that you have the following, just gotta find them. I know them, I just gotta find them. So you have the following trial rights. You'll be pleading guilty to count 1, which is punishable by 93 days in jail and or $500. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have witnesses against you appear at trial. You have the right to to question those witnesses. You are represented by Attorney James Harris, and he would be present to cross-examine any witness or contest any charges brought against you by the people. You have the right to have the court order any witnesses appear in your defense. You have the right to remain silent during the trial. You have the right not to have that silence used against you. And you have the right to testify at trial if you choose to testify. If your no contest plea is accepted, you'll give up the claim the plea was a result of any promises. Other than what's been stated on the record. Or threats that it was not your choice to plead no contest. You'd also be giving up the right to appeal anything from trial since you'll be pleading no contest instead. Is it still your wish today to plead no contest to the count 1 misdemeanor domestic violence?
Yes.
Okay, thank you. I'm going to, so for the factual basis, based on lack of memory, we're going to refer to the case number pursuant to stipulation of counsel is 255-1903-171. And that was forwarded to me. Is that the correct, no contest factual information, Mrs. L?
It is, Your Honor.
Mr. Harris?
Yes, Your Honor.
All right. So I find that this occurred on the 618 South Sycamore Street in the city of Lansing on April 5th, 2025. It appears that officers Idalski and Peterson were dispatched to that address. And it is alleged that Mr. De Leon struck his girlfriend multiple times in the face. It does appear that Mr. De Leon was intoxicated at the time. And the two were living together at the time. Or at least were in a dating relationship. Anything towards a factual basis, Mrs. L?
Nothing further, Your Honor.
Mr. Harris?
Not from the defense, Your Honor.
Right, I find that the factual basis to, based on the police report for no contest due to lack of memory to be sufficient. We'll refer to probation. And so probation is one floor down on the 5th floor, go all the way to the right. And Mr. DeLeon may need assistance with the translator on that for that purpose. What they'll do is they'll ask you questions and they'll prepare a report for me, and then we'll see what options are available to us at sentencing. We have a sentence date of
July 1st at 1:30.
July 1st at 1:30 for sentencing. And then Mrs. L, did you want to still be heard on bond?
Yes, Your Honor, if we may. At this time, Your Honor, the victim or complaining witness in this case has asked for the no contact order to be removed. I did speak with the victim at length with a translator yesterday, as well as with a victim advocate, and she did express that the no contact order being lifted were her wishes. She does believe she will be able to stay safe over the term of probation with the no contact order lifted.
All right. And you indicated that Miss Garcia is here today.
She is, Your Honor. She is present in the courtroom.
All right. And anything you want to state or any objection, Mr. Harris?
I have no objection, Your Honor. I would request the no contact order be dropped if that is the witness's wishes. And she believes that she can remain safe with it dropped.
So the no contact order is modified at the prosecutor and complaining victim's request to negate or strike the no contact order. Mr. De Leon is still on TPS. That would be a tracking device then.
It would be, Your Honor, if the court were inclined to remove that GPS tether. We would not object to it, but
let's leave it for after probation. Let the probation decide. I don't think it remains as a tracking device. but we'll let probation come back to say what they think is necessary. I certainly understand that there's a lifting of the no contact order at the victim's request. Mr. Harris.
If that is the client, if that is the court's decision, Your Honor, I will accept that.
All right.
My client has indicated it does cause him some pain. I will advise him that he can go maybe have it adjusted at the location where it was put on, but that it will not be removed today, and we will renew that request at sentencing.
All right. And then tell him to refer any type of to the probation agent but we'll leave it on until the probation takes it off. Okay. So that would be GPS for tracking. All right, so Mr. Leone, please go to the 5th floor and then set up a time to meet with probation in order to set up a meeting or meet with them at that time. Anything else? And then we'll see you on July 1st. Is it July 1st?
Yes.
July 1st at 1:30. I would, for the no contact, you'll get a note, you should report to probation. I would give at least to purge the no contact order the afternoon, just to purge it from the system. Because it's going to be in the computer system and throughout the afternoon, I would think. So it takes about an afternoon to get the no contact order out of the system. Now return the factual basis. Anything else for the record in 25-01031, Mrs. L?
Not for the people.
Mr. Harris.
Not from the defense, Your Honor.
All right.
Permission to approach?
You may. All right, Mr. Ustelione, we will see you on March 1st at 1:30. What's that?
July 1st.
July 1st. July 1st at 1:30.
Thank you, Your Honor.
Thank you. Thank you for your assistance today. We're going all these Scott files.
Your Honor, permission to approach?
You may. Oh, that, so I think Megan signs this, or Wendy. I think it's the translator paperwork.
Request paperwork.
I'd sign it, but I don't know if I'm supposed to. Bonnie ultimately gets it, right?
Yeah.
I think Bonnie gets
I
it.
think so.
So, hold on a second. I don't find any numbers.
We have all these.
Update or will you?
Oh, I already know what the update is. I just know. Oh,
I think we all wanted to. Even you wanted to get some.
I did.
So I'm assuming she's not coming. Oh, because you haven't talked to her.
All right, let's call the Scott cases.
Yeah.
So we're on the record in docket 25-00651. So 25-00651, 652, 00751, 3469, 3470, 3672, 03673, 00063, 00064. That's 25 for the first three, 25, and then 24 for the second four, and then 25 for the last two. Appearances for the record, Mrs. L.
Thank you, Your Honor. Gabrielle Ezel, Assistant Prosecutor for the people.
Mr. Harris.
Assistant Public Defender James Harris here on behalf of Angela Scott, who unfortunately is not here today, Your Honor.
Right, and Mr. Harris, have you had any contact with Ms. Scott?
I have not been able to make any contact. I have tried getting in touch with her via the email address she provided, and that came back bad. And I have tried both of the numbers we have on file multiple times and have at best gotten voicemails. I have left voicemails regarding the court date. In each one I have advised what the date and time of the court date was, that she needed to appear in person, and that where she would need to appear. Unfortunately, I have not been able to make contact with my client, Your Honor.
All right, it would appear that Ms. Scott is not on the Zoom courtroom or physical courtroom, and based on the representations of counsel, Ms. Scott has failed to appear today for these pretrials. Mrs. L, how did you want to go forward?
Your Honor, at this time, it's our stance that Ms. Scott has had plenty of notice for today's court date, so we would be asking for a bench warrant to be issued in these files.
All right, and is there any previous fail to appear on these?
I believe there are on several of the files.
Okay.
However, I believe there are three or so files where this would be the first failure to appear.
Right.
I would request, if possible, the court to consider a 48-hour hold, but given the failures to appear on the other files, I will leave it up to the court's discretion regarding whether they issue the bench warrant immediately or not.
Because of the amount of files, and there is a multitude of failed to appears, at least on 3 or 4 of the previous files, we'll issue an immediate bench warrant and bond forfeiture. These are all dog tickets or unlicensed dog, but there seems to be collectively for a fail to appear on at least 1, 2, 3, 4, and then Ms. Scott has come on some of the files previously, so I'll issue a bench warrant and bond forfeiture for the fail to appear. And then, Mr. Harris, if you hear different and you need to get her in, we'll get her in. We can arraign her. Just let my staff know.
Judge, I just let an iPhone in.
All
Judge
right.
Dillard was very specific with her.
All right. And on the iPhone, could you please identify yourself?
Yes, this is Eric Weber. I'm sorry.
Eric Weber.
Yes.
And do you have a case number, sir? Because you're not on our docket.
Yeah, okay.
What's your case number?
I'm looking. It's an 1131.
Yeah, we don't have anything for 1130, but I bet you are in another courtroom. So let's see if we can find the right courtroom for you.
Okay. Case number. Jeez. Are
Your
you
name
guys
is Eric Weber, Weber?
correct?
Get under that one. For 11:30 today. Eric?
I have nothing on the criminal side. Weber.
Weber.
I have nothing on the criminal side. Let me check.
Are you involved in a criminal case or a civil case?
So I filed a claim.
Sounds
and,
like a civil case.
Yeah. So it's at 11:30.
In front of what judge?
See, again, I'm not sure. It might be a magistrate. I'm homeless right now. I'm in like a mini mall. I could ask my, I could look for the information you're looking
So
for, but
we have you in front of Judge Buchanan at 1:15. And let me give you that ID number at 1:15.
excellent.
Okay, I give him the meeting number or the call number? For Judge Buchanan.
The meeting ID.
Okay, the meeting ID for Judge Buchanan is 862
862
675
675
555
555
4.
4.
And that you should be on Judge Buchanan's docket for 1:15.
Okay, 862 675 5554.
Correct.
And that's Judge who?
Judge Buchanan, Buchanan.
Okay, Judge Buchanan. Thank you very much, Your Honor.
You're welcome.
Is Judge Buchanan still in her jury trial?
She's gonna try to handle some things, and what she can't handle will get shipped out depending on what status they are.
All right, so let's go back on the record on Angela Scott. We have a bench warrant and bond forfeiture on 25-00652, 25-00651. Bond forfeiture on 25-00064. On file 25-00063. A stack. Megan's gonna have some bench warrants on 24-03673. On 24-03672. On 24-03470. And 24-03469. And on 25-00751. So those are all in bench warrant status. So thank you, everybody, for your appearance on those. And then Mr. Harris, you have Miss Thurman this afternoon, is that correct?
Yes, Your Honor.
All right. All right, so we're on the record in docket 22-03062. That is people of the state of Michigan versus Brian Thrush. Will the parties please introduce themselves for the record? Mr. Martinez.
Good afternoon, Your Honor. Joel Martinez appearing on behalf of the people of the state of Michigan.
All right, Mr. Leone.
John Leone on behalf of the defendant, Mr. Thrush, who's sitting to my right.
All right, and sir, you are Brian Douglas Thrush, is that correct?
Yes, Your Honor.
All right, thank you. This is the time set for a delay in sentencing that was scheduled on October 28, 2024. And I am in possession of a report in regards to the delay in sentencing. Mr. Martinez, how are we proceeding today?
Thank you, Judge. I actually have not had a chance to discuss this with defense counsel. I just arrived a moment ago, Judge. I did review the report. My understanding of the proceedings that have gotten us here today is that the defendant entered a plea in this matter. It was put on a delay status. I'm not sure if it was under 771.1 or something else, Judge.
I have 77.1. It was not done by Mrs. Zell. I think it was done by a previous prosecutor.
Got it.
Is that a fair statement, Mrs. Zell?
Yes, Your
I think
Honor,
Ms.
it was done by Ms. Wilson.
Ms. Wilson, okay.
The delay agreement essentially was that the defendant was going to get a psychological evaluation, follow any recommendations outlined in that psychological evaluation. I'm in possession of that. The evaluation was done. No recommendation was made. It appears that the reason no recommendation or diagnosis was reached, Judge, is because the defendant appeared and said that he had used some sort of bug bomb in his residence to get rid of some ants. And that is the reason that he had somehow gone into some form of psychosis or mental health crisis, and that was the cause. I don't have any, correct me if I'm wrong, if I say something that's incorrect, yeah, please do. I don't have any reason to believe that, I don't have any information about this bug bombing. I don't have any reason to believe that that was the cause of his mental health issue. I believe mental health was the concern prior, Judge, or else we never would have agreed and we never would have entered into this agreement and said, let's get him a mental health evaluation if it wasn't a concern already. Additionally, he spent quite a bit of time, apparently, I'm reading from the report here. It says for weeks, he was in and out of psychosis. He was, quote, going crazy. He was taking psychotropic medications. He was in a psychiatric ward. I don't have any reason to believe, Judge, that that was due to being inside of a house that had just been bug bombed. That's his statement.
I hate to interrupt, but he's now practicing medicine.
Judge, may I
We've
finish?
been through all of this.
Mr. Loney, I'll give you your time to talk.
I
so-
apologize.
Yep, and I won't interrupt, I promise, when it's your turn.
All right, Mr. Martinez.
I'm not practicing medicine. I'm simply saying that, you know, if everyone starts to show up to these psych evals and says, oh, I had a bug bomb at my house and that's why I'm having these mental health issues, Judge, there will never be mental health ordered then or recommended. Everyone would just say, I've bug bombed my house and that's why there's a recommendation or no recommendation. So I am of the belief that this is an individual who had a mental health issue, mental health crisis, and it was not treated because of the information he gave to them, Judge. A lot of this is done by self-report. I get that, but I don't believe that was done in good faith. I do not believe that they engaged in this in good faith, and that's my position. I turn the floor over to counsel.
May I ask
All
a
right, Mr.
question?
Leone.
Yeah, may I ask the question, what particularly was not done in good faith?
Well, I'm not going to have a conversation with you on the record, sir. You can address the court, though.
All right, Your Honor. Well, I'm not sure what he's talking about. First things first, Your Honor. I owe an apology for my volume, but not my tone or any of the content of a conversation I had with Ms. Ezell beforehand. Your Honor, we have a prosecutor here who's admitting he really doesn't know this case at all. We have a man here who has an absolutely spotless record, grandfather of four, has had his own business, never had a parking ticket. And the record was clear for the attorneys, that the prosecutors that were handling it, that there's all the medical evidence in the world. There was video, everything available to them, that this was that he did poison himself. You know, rather foolishly, he did a bug bomb in his own home, thought it was okay to sleep there at nighttime. So this is all in their record. So we have not the original prosecutor and then a prosecutor who came in and now they have, probably because of my behavior, which again, I apologize again, only for my volume. Because I have for you, Your Honor, I mean, to cut to the chase, what the agreement was given, I would think it's rather than to try to surmise on medical evaluations, But what the agreement was, after full discussion of the entire history, all the medical, all everything. In fact, the victim, if you will, what happened was when he was taken to emergency one time and the medical records show he's having a psychotic moment, he punched one of the treaters who was brought here, not voluntarily, he was told to be here. And for what it's worth, Your Honor, my information is that he wasn't, it happened 2 years prior to the charges being brought. So that's what we have. Someone with a grandfather, spotless record, who's had his own business forever. In fact, I've known him for 4 years, Your Honor, personally. And he does landscaping and went for full disclosure on properties that I have. But to try to cut to the chase, rather than try to relive, doing it, Mr. Prosecutor to my left here is doing his best to surmise what the record is. But I was here for the whole thing. And I have the very words, Your Honor, if I may, of both the original prosecutor, Ms. Abigail Wilson. These are your copies, if I can just read one sentence out of each. During that time, meaning the 6-month probation, and by the way, this wasn't actually sent to probation.
Right, this was just delayed.
Okay, all right. During that time, during probation, Mr. Thrush must obtain a psychological evaluation and comply with treatment recommendations. If he is successful at the end of the term, the case would be dismissed. That was the understanding. It got transferred, this case then got transferred over to Ms. Ezel, if I have that correctly, and she writes February 25th of this year. It is my understanding that the agreement was for a term of 6 months probation, and upon successful completion and evaluation, she missed the part about treatment recommendation, but that's fine. The assault and battery would be dismissed. So in what I have for you, Your Honor, it's, you can see in the evaluation. So we're going by the very words. And what I submit to you, Your Honor, if attorneys and the citizenry is to trust what prosecutors, what they say is, the deal, the plea agreement. I asked, where I got in a little row back and forth was I was expecting the prosecutor's office to happily announce that they agree with the dismissal because this fine citizen who messed himself up, paid the full price, did everything he was asked. And if you look at the evaluation and again, what was most, the toughest requirement was get a psychological evaluation by anyone with a license and comply with treatment recommendations. Well, I read from the report in the conclusion, no mental health treatment or intervention is indicated or needed at this time. In addition to other things saying that he's fine now, he works, he's got a fantastic life. So if the citizenry around here is supposed to trust that the prosecutors don't just robotically go full bore against everyone, I can't, I'm trying to picture anyone, a better example of a citizen who messed up and not in a way that he was, doing something wrong to someone else. He accidentally poisons himself. Yes, it lasted how many months roughly? 3 months of, yes, this poison was in his head. So and I can only pretend to understand the caseload that prosecutors have, Your Honor. But it seems to be that the training, my guess, from my experience being around, the training that's coming from the top is to just go hard on every single thing. This is the poster man for a case where the prosecution, who represents the people in this community, says, this guy did everything we asked. It's clearly an aberration. When I got in a little back and forth with Ms. Ezel before, she actually asked me, and I don't know if I have the quote exactly right, well, how is this one poisoning different than a drug user? I mean, she might have said drug addict, but drug user. Everything's different. He didn't do it intentionally. He did it once in his lifetime. And the entire record is a man who poisoned himself, went through this horrible scenario, punched a man, and is paying the full price for it, and has done exactly, these are the words here, Your Honor, if you want your copy, to clarify what this man needed. And they said would be dismissed. And I would ask this court to hold the prosecution to their word, not just for my client, Your Honor. I want to be able to tell other attorneys, other citizens that are sitting here in your courtroom, that this prosecutor's office does what they say. So if you're interested, I have those emails, Your Honor.
Right, Ms. Martinez in response.
Thank you, Judge. So I don't know Mr. Leone, and I wasn't here when the discussion happened with Ms. Azell, Judge, but the way it was described to me, the tone, no, I trust what you're telling me.
Okay.
I trust what you're telling me.
It's copies.
Mr. Leone is apologizing for his volume, but not his tone. I think there should be an apology for tone as well, Judge. And yeah, you can laugh if you want to laugh, but
I'm not laughing.
The way that I operate and the way my office operates in Ingham County is with decorum and respect, and not, this isn't whoever shouts the loudest is going to get their way. So Mr. Leone appeared in court today thinking there was going to be a particular resolution. That's not what he heard from Ms. Azell, and in my opinion, became very unprofessional. Now, to say that the prosecutor's office goes full bore and that we're somehow just arbitrarily prosecuting this man, Judge, the agreement was to dismiss this upon a certain agreement, right? It's an assault. He punched someone in the face. That doesn't sound like full bore. It sounds like we struck a very favorable resolution for the defendant here, Judge. It doesn't get any better than a dismissal. Full bore would say no offer, we're going to go to trial. That's full bore, not we will agree to have this delay, get some treatment, then we'll dismiss. That's not full bore, Judge. So again, sort of mischaracterizing not only what my office does, but what happened here. I don't want to beat a dead horse, Judge. I don't believe that the spirit of this agreement has been complied with at this point, and I'm not in a position today, Judge, to put on this record to this court that I'm moving to dismiss this case at this time.
All right.
Thank you.
Thank you. So this was a deferred sentencing. Realistically, my response to is to refer this to probation and let them decide what's going on here. I do have a self-reported report. So Mr. Thrush was the only. I don't have any indication that this has any other anything else in Mr. Thrush's word. He is the sole reporter to a Spencer Price, who we could call as a hearing, and we could talk to Mr. Price, see how long he spent with Mr. Thrush, see if Mr. Thrush was the only recording, see if you looked at anything else concerning any mental health history concerning this matter. I'm able to set it for hearing for that date and have the party subpoena Mr. Price. I'm not convinced at this point in time that this is really the spirit of the agreement.
I have the word of the agreement.
That's interpretation of the word. That's your interpretation of the word. Mr. Leone.
I'm sorry.
No. Go ahead, speak.
These are the words of the prosecutors.
Correct.
Saying exactly what's needed in the detail of what the agreement was. And it was just get an evaluation and follow any treatment recommendations.
And so the evaluation is whatever you say goes, and because I don't see anything wrong with you, you shouldn't have to do any type of treatment or follow-up.
From the licensed
professional. Well, let's bring the licensed professional in here and have them discuss this with us.
If you feel somehow, and I'm sorry if I've somehow.
No, you have not. I want to get to the truth here, and the truth here, I have Mr. Thrush's word to the licensed professional, and the licensed professional is here, and we can bring the licensed professional here and have everybody I don't know how long Mr. Thrush spent with the licensed professional. I don't know this licensed professional. I know people from Child and Family Services, but I don't know this person at all from Child and Family Services.
If Your Honor, for some reason, does not feel that the very report.
I don't.
Was agreed.
I do not.
So you don't have.
I do not feel that report gives me the opportunity to dismiss an assault and battery in this matter. No, it does not.
And if I may, Your Honor, the history of him having, everything points to a one-time poisoning by someone who had no history.
I would love to see that in writing. I would love to see that the history, Mr. Thrush's history, has been evaluated by the professional, which it's not in there. There's no history. There's no history in there. All that's reported is what Mr. Thrush has told the profession. That's all in regards to the bug bomb and in regards to the assessment. There's nothing else in regards to any treatment, Mr. Thrush, and there could be no treatment of Mr. Thrush. Would we give Mr. Martinez also the indication that, look, this is a one-time event, but I don't have any of that.
Well, can't disagree with the court. It seems that that's what the report says and the.
But
report does
show
say.
me the history. Show me the history in that report.
Okay, background. There's a background section where, it's all self-reported.
It's all
So are you
self-reported, but
saying-
I would say anything else but the self-reporting. Is there anything else not pertaining to this incident?
This is what I'd like to do.
No, I'm looking to ask you, sir, is there anything in the background history which would indicate that this comes solely from this incident and not from something else?
His opinion.
Right. And so let's get him here and we'll ask him his opinion.
Well, this is what I would suggest, Your Honor, just to save time and expense on this misdemeanor matter that happened 2 years ago, is to, if it could be indicated what additional, rather than bring him here in person and interrogate him and the cost of bringing an expert, to have what would be needed for him to do a fuller report.
I think bringing in the expert who did the report would suffice.
Your Honor,
I'd like to see how long he spent with Mr. Thrush. I'd like to see what else he looked at. I'd like to see if it was anything else but the reporting of Mr. Thrush in order to dismiss a case. Remember, we're not talking about probation in a matter. We're talking about a dismissing an assault and battery, something your client has already pled no contest to.
Correct, Your Honor. Right. And I was just, from my experience, looking at the constellation of all these factors, who this individual is, his entire life, everything indicates this is an aberration done to himself by accident, and his behavior since the recovery from having the poison in his head has been exemplary. Nothing. I don't understand where there's an indication that he poses any risk.
And the deferred sentence was to have this case dismissed.
Yes, Your Honor.
Right.
It says just have him evaluated and follow recommendations.
Right. I think
accepting the evaluation.
But I want some clarification as to the evaluation.
Okay.
I want some clarification as to this is a one-time January 22nd evaluation concerning Mr. Thrush and what he reported, and then what the practitioner took into account. Now, if the practitioner is taking into account other mental health problems that we are not known about because nothing is reported in this 2-page report, then we have at least some information as to what the decision was made upon. All I read here is that he was susceptible to a bug bomb that affected what he did, and that he blacked out and hit somebody who was trying to treat him at a hospital. That seems to be problematic to me. If that's the case,
there's nothing else to report on the man. I'll submit to you because
we should ask Mr. Price what he determined his opinion on.
I don't know what he would go beyond.
Well, if he's going to say I didn't go beyond what was told to me, then I have my answer.
Well, but if this is insufficient and all he's going to do is say I've got everything in the report, Your Honor, then we would be right back here again. So
exactly.
I guess I'm asking the court
we've talked to the therapist and in person and subject him to direct and cross examination, which is what we do in a courtroom, as you know.
Correct. If you feel the report which you've indicated
based on what I see, there's nothing outside that your client had anything but a bug bomb.
Yes,
correct.
And there's no, and that's because that's.
So if that's what the decision was made upon, and there was no other, and there's a history of mental health, let's find out about it. If there is none, or the opinion suggests only that, then I have my answer.
Can I ask then, because rather than try to do this right now in front of Your Honor, can I ask for an adjournment of this same hearing? And rather than go to the expense and time of bringing this man in, which I would have no problem except for the time and expense on this misdemeanor, and that's maybe get an additional affidavit or get from you, what additional records would you want him to indicate?
Any additional records, anything else that would convince the court that a dismissal is, all I have is that he used an indoor bug bomb, and that was attributable to the blackout, which occurred, an assault and battery happened during the blackout. Yeah. I don't have if he asked any questions concerning whether Mr. Thrush has a history of mental health. I have all I have is that. And if you can show me where I'm incorrect, I'd be happy to look at it. I don't see anything else.
That's what I'd like to do, Your Honor. Look at this. And you've also indicated,
But you came prepared today. I mean,
Yes.
you asked for the evaluation on January 22nd.
Yes.
So you would know what's in the report.
Yeah, I do. And I'm trying to, well, can I ask for this? Can I sit down, look at this rather than stand up here in front of you, see if some of those items are in here? Or I can do it just standing here, Your Honor.
Well, either way, or we can, I think having the professional here to answer your questions, having Mr. Price here, and subject him to direct and cross, he's willing to write the 2-page report. He should become and he should answer as to the report he's written.
Correct. And we're
And it's not a small matter. We're getting a dismissal based on the report, not like a probationary term. We're dismissing a file in which the no contest plea was somebody was hit in the face. A first responder was hit in the face.
Yeah, I understand that, Your Honor. He denied, no, again, it's just Mr. Thrush with his therapist. He denied any current and or historical problematic use of substances of abuse, stating never.
So he's indicated he's never used a substance abuse.
What I would prefer, and maybe right now, put Mr. Thrush on the stand.
Yeah, but see, that comes from Mr. Thrush. That's the same problem we had before. I believe, and it's not to say I don't believe Mr. Thrush, but I want some confirmation, especially if we're making a determination based on the report.
Well, the problem I see, to not waste this court's time, is to bring Mr. Price in here only to repeat, this is what I asked, and these are responses. It doesn't get this court further into what apparently it wants, which is more of a basis for an opinion.
Well, I'd like to know, like, what was Mr. Price told his role was? Why did he see Mr. Thrush? What was the evaluation for? Things of that nature.
Okay. Okay, well, again, I don't get argumentative with you. It seems that it's in here that when someone goes into a therapist, that's why I'm asking just one real.
When somebody goes into a therapist, it can be for many reasons.
Correct. I guess then I become a witness because I'm the one that communicated to him and said what the scenario was. I communicated to Mr. Price and said he just needs an evaluation. And it seems to talk about his history, but I thank you, Your Honor, for your time. I know you're being very patient with me.
Well, no,
I'm just trying to not come back and end up in the same place.
Right, we have a report that's leading to dismissal, and I want clarification on the report because I don't think the report says. I understand your argument. Your argument is they agree to the report. Based on the report, they should dismiss the case. And I need something more than just the report from your client indicating that on this time he has no memory of the event and therefore it should be dismissed. I guess I'd like to know how much time was spent because you could deliver this in 10, 15 minutes.
That's what I'm trying to understand is get these additional.
Well, let's get him here. Let's get him here.
Okay. Well, that's apparently you're ordering.
Yeah. So let's adjourn the delayed sentence. We'll adjourn the delayed sentence to get the reporter here for any questions, and that would be from Child and Family Psychological Services. That would be D. Spencer Price, who's a clinical therapist. He's an MA, LLP, CAA, DC, CCS. I don't know what that means. But we will take that report and we will indicate whether it suffices for your purposes of dismissal of the assault and battery. If not, then he should be present to be cross-examined. I don't have a problem if he's here by Zoom, but I'm not in an adversarial setting. So, Mr. Martinez, do you have a preference?
Is he coming in from Kalamazoo?
I would assume that's.
I see Kalamazoo and I see Portage. I see two offices.
Kalamazoo, where that office is, quite frankly,
I don't know where he's at and from Child and Family.
But I thought I might have heard you say something about if there's discussions with the prosecutors after this hearing that I mean, obviously it's your.
If there's further discussions and negotiations to continue concerning the delayed sentence, that's fine. I have no worries about that.
Including the possibility that the prosecutors may accept this report as sufficient.
Yeah, I'll wait to hear from the prosecutor's office, but I want to say that our staff is okay with Zoom. Okay. Now I understand in an adversarial setting that we may have to bring him here, but we've done mental hearings before by Zoom, and so that would be available if that would suffice both parties hearing the request, because I would assume that Mr. Price is busy and testifies, and so we'd have to line it up.
Might the prosecutor's office agree to just directly speak with Mr. Price, even if he's sworn in, and determine whether you think his report and subsequent information is sufficient?
You mean off the record, not as a part of a court proceeding, just call him and speak to him?
Yeah.
Oh, I'm happy to, not a problem. And Judge, if we do get to a hearing, I have no problem with Dr. Price appearing over Zoom. Not a
Okay,
problem. I'm
all
fine
right.
with that.
All right, so let's adjourn the delayed sentencing without date at this time, because we don't have a date, so to speak, because we got to make sure that it goes with Mr. Leone's schedule, and Mr. Martinez, you're subbing in on this. We want to make sure it goes with your schedule, but let's have a control date. Let's set it for control date so we don't lose track of it. And I would say 60 days out for control date, if not soon. That's the optimum time that we will look at the file again. It may be resolved before that, or we may have a hearing before that. I just don't want to lose track of it.
Thank you.
Yeah.
Thank you, Your Honor.
So we'll control date it at June 17th at 1:30. And then I'll wait to hear from the parties if we want to have a actual hearing, and we can set it for a date. We'll probably set it for an afternoon that has only the witness come here via Zoom. So we have some leeway concerning the testimony. But the delayed sentence is adjourned until we have some clarification as to some of the indications that were made by Mr. Price concerning the report. Anything else for the record in 22-03062, Mr. Leon?
Only that I hope my behavior before this hearing started did not influence any of the proceedings.
It has not. Trust me, we've much more vociferous litigators than you, so you're fine. But I'll ask is to treat the opponents with respect.
And I guess the final thing I would say, if there were particulars like that the prosecution wanted to see, like the report has to include a review of the medical records, and that would have been helpful, Your Honor.
Right.
But I was just told, get an evaluation by anyone licensed.
Right.
The evaluation does touch upon its history. I know I'm repeating myself, Your Honor, so thank you.
All right, Mr. Martinez, any communication you want to have with Mr. Leone concerning the file and some things you're looking for in regards to the delay in sentence? But if we come to an impasse, let's have the witness here and we'll make a clarification of the report, okay?
Got it. I appreciate the court's time.
Thank you.
Thank you.
Thank you, sir. Two o'clock Chase, but nobody's here. And then we have whatever. Then we have whatever we're doing for Judge Buchanan.
I don't know if she emailed you with these.
She did not.
I don't, yeah, I gotta find him in OnBase and try to help you do that, and I don't know if she sent that. To be perfectly honest.
Ms. Tolzman, did you come from Judge Buchanan's office?
I did, yes.
Or she's running a jury trial. So we're taking whatever overflow, but let me see if I can pull your case up.
Okay.
All right.
And Judge David said if we need to adjourn anything, Judge Buchanan said that's perfectly fine.
All right. And then Mr. Bach also had, Mr. Bach, you have a hearing that's going, is that correct?
No, sir, we have a CD now.
All right, let's see if I can find the cases, because they're not my cases, but we can move those cases.
And go for it, says you're.
Go under Buchanan?
And click down to Buchanan, I think. You want to sign this before we forget that.
Yes,
'Cause she's
this
in-
is on Miss
Yeah,
Thurman.
and she's in jail. These are facts too.
I do on, these are two on Miss Thurman. Is Miss Hughes on, I don't have her on the case credit union that we have. Let's one case at a time.
I was gonna say, do we maybe do this slower than we usually do?
Yeah, one case.
I seem to be struggling.
Is it under prep complete or hearing document? You
Should
said
be in
under
your
bench,
bench.
okay. I'll pull up. Buchanan. Mr. Bach, what's the name of your case?
It is Todd Dowrick and Keith Pyron.
All right, I've got that. All right, Mr. Bach, you can come up here with Mr. Pyron. Mrs. L, I think that takes care of our criminal matters today.
Yes, Your Honor, thank you. Knowledge.
All right.
Before she can go.
According to Wendy Orr, one knowledge.
That's right.
All right. So all right, Mr. Pyron, you can come up here. You're fine. All right, so we're on the record in docket 25-00645. That is People of the State of Michigan versus Judge Buchanan. I just called out my colleague. That is Todd Dowrick versus Keith Pyron. Appearances for the record, Mr. Bach.
Yes, good afternoon, Your Honor. Ronald Bach here for the plaintiff.
And sir, you are Keith Pyron, is that correct? All right, thank you. This is the time set for a landlord-tenant matter. And I'm hearing this because Judge Buchanan's in a jury trial.
Yes.
Is each party okay with me hearing the resolution?
Yes, sir.
All right, thank you. This was previously seen on April 1st by Judge Buchanan. Mr. Bach, how we proceed?
We've got agreed to a consent order for conditional dismissal. The facts are Mr. Pyron has already moved out. So what we were here today trying to get to the bottom of is how much back rent is owed. Through some discussion in the back room, we've been in agreement.
So it's a conditional dismissal or
Yes.
consent to, okay.
Conditional dismissal.
All right.
Case will be dismissed.
And do you want to place those terms on the record?
Certainly, Judge. Well, we've calculated, he moved out on March 11. That was the date that the original default judgment was signed, which ended up getting set aside. At that time, the rent through that date was $1,274.32 with $138.64 in costs for a total money judgment of $1,412.96. But Mr. Pyron is going to pay $500 on May 5th, $500 on June 5th. As long as he's paid that as agreed, plaintiff will accept the $1,000 as full and final settlement, and this case will stay dismissed.
All right. And do you have an order to that effect, Mr. Bach?
Yes, may I approach?
You may. All right, Mr. Pyron, you've heard with the indications made by Mr. Bach on the record. That's all agreed to by yourself. Is that correct? Yes, sir. All right, and you signed the bottom of this document. Is that correct? Sure. All right. I'm in possession of the consent order for conditional dismissal on 25-00645. Based on the terms placed on the record, defendant shall pay the following to plaintiff box. That box is checked with the total amount being $1,412.96. And then the terms of the payment plan that's been set up by the parties. Box B is checked that this action may proceed without notice to the defendant or further further process. Mr. Pyron, you understand because you are not represented by counsel that you have 3 days from today's date to say that although it seems fairly straightforward with the payment plan, that what we did here was vague or ambiguous to you. Do you understand that, sir?
Yes.
Okay, thank you. So I've explained Michigan Court Rule 4.201J to the parties, and I will sign at the party's request. And then we will sign and scan the order. And provide any copies for your records. All right, Mr. Pyron? All right, Mr. Bach, we'll provide any copies of the document for your own records. Do you have any questions of me, Mr. Pyron? All right, Mr. Bach.
No, thank you.
All right, we're all set. You can get your copies from my court officer. Thank you for your patience. Right, and this, I just said your name.
Tolman.
Ms. Tolson. What case are you here on, ma'am?
I have two LG Park Places,
Okay.
Peterson, we have a consent judgment, and then the other one we have maybe a hearing.
All right, that's N Len.
Yes, correct.
All right, let's do the Peterson case first.
Thank you, Judge.
Thank you, Mr. Bach. All right, so we're on the record in docket 25-01367. That's LG Park Place versus Shante Peterson. Will the parties please introduce themselves for the record? Ms. Colson.
Alex Tolman appearing on behalf of the plaintiff.
And ma'am, you are Shante Peterson, is that correct? All right, thank you. This is the time set for a landlord-tenant hearing. Does any party have any dispute with me handling the case for Judge Buchanan? Ms. Toltzman.
No, Your Honor.
Ms. Peterson. All right. This was a case previously seen by Judge Buchanan on April 1st, 2025. Ms. Toltzman, how are you proceeding?
Yes, Your Honor, this is a non-payment of rent case, possession judgment and a supplemental claim for money judgment. We've reached a consent judgment for the possession portion. Rent to retain possession is $3,862.74. There's court costs of $258.79 for a total outstanding balance of $4,121.53. Defendant is to pay that amount or vacate on or before May 9th, 2025. For the supplemental money judgment claim, there's damages prorated in the amount of $3,836.11. Same court costs of $258.79 for a total prorated money judgment of $4,094.90. Both myself and Ms. Peterson have signed that document.
Do you have an order to that effect, Ms. Toltzman?
I do, Your Honor.
All right, thank you. And that May 9th date is the 10-day statutory date.
Correct,
Okay.
yes.
All right, so I'm in possession of the consent judgment. And Ms. Peterson, you signed the bottom of this? You've heard you heard everything that Ms. Toltzman placed on the record. Was there anything that she placed on the record that you did not agree to? So you have to say yes.
Yeah.
All right, thank you. Box 1 is checked. The plaintiff has the right to recover possession of property. Box 2 is checked. I make a determination that the valid waiver of rights exists and the terms of the consent judgment are fair. There's a total of $4,121.53. That comes along with a $258 charge of court costs for 4A for May 9th being the 10-day statutory date for May 9th. Box 6 is checked that a partial payment will not prevent the court from issuing an order of eviction. So partial payment will not prevent that. And then the money judgment at the prorated amount is also checked. And that would be box 9. I'll check that. Those are kind of checks. I see what you did.
Kind of X's.
Yeah, kind of X's, kind of checks. All right. Ms. Peterson, you understand that you have 3 days from today's date because you're not represented by counsel to say something we did here was vague or ambiguous. Do you understand that?
I understand.
All right. I will sign the consent judgments. For our purposes. And you can both get a copy of the consent judgment for my court officer, all right? Anything else for the record in 25-01367, Ms. Toltzman?
No, Your Honor.
Ms. Peterson, do you have any questions of me?
Your Honor.
All right, you should be all set. Thank you for your appearance today. So the other Park Place was NLN?
NLEND.
All right, so let's call that case. So we're on the record in docket 25-01368 LT. That's LG Park Place LLC versus NLEND. You can come up here, ma'am.
Thank you.
So will the parties please introduce themselves for the record? Ms. Toltzman.
Alex Tolson appearing on behalf of the plaintiff.
All right, and ma'am, you are Ann, and then help me pronounce the last name, Lend or Len? Len?
Yes.
Okay, that's spelled Nland.
Yes.
All right. This is time set for a landlord-tenant hearing. This was previously seen by Judge Buchanan on April 1st, 2025. Are there any objections to the court having this hearing, Ms. Toltzman?
No, Your Honor.
Ms. Lend? If you'd prefer to have Ms. Judge Buchanan, she'll just reset it for herself. We're doing this so because Judge Buchanan has a jury trial going on right now.
Okay, I can speak by myself. I don't have.
You don't have a lawyer. So did you object to me hearing the case for hearing, or did you want to have Judge Buchanan here?
Anyway, it's fine for me.
All right. So without objection, I will accept it as hearing it today. Ms. Holtzman, how we proceed?
Your Honor, I had the opportunity to speak with the defendant. My understanding is that there is no dispute in the amount owed, including rent to retain possession and costs. We just couldn't come to an agreement on a deadline to get that paid or to vacate. So unfortunately, I don't have any consent judgment or conditional dismissal in this matter.
All right. Do you have a number that's not in dispute?
Yes, rent to retain possession is $3,350. I show court costs of $258.79 for a total outstanding balance of $3,608.79. This is also a money judgment claim, so that prorated figure, including costs, is $3,535.79.
All right. So the indication, Miss Land, is that you're not disputing the owed money amount of $3,608.79. Is that a fair statement?
Yes.
Okay. And then the money judgment, which is the prorated amount, they do it by day, would knock that down. The money judgment would be $3,535. That's just going per day per month. So you wouldn't be charged for the entire month. That's why it's lower, $3,535.79. Do you understand that, ma'am? All right. So if you're not disputing it, the real question is the move out date, right? So I don't see a legal issue that we're dealing with. What I'm seeing is that the parties are discussing, and by law, she has 10 days to ask for an order of eviction. Okay. So she has till May 9th to ask for an order of eviction. She can come to the court and ask for an order of eviction. I don't know if there's any leeway on that, but that's the 10-day date. Are you seeking a date past that 10-day period?
I cannot pay at that time because I don't have a job for now.
Right. So we're not talking about payment anymore. It would pay or be in possession of by May 9th. It appears that you couldn't pay by May 9th, so she could come and ask for an eviction on that date. Are you looking for? So you'd have to find a place to move, a new place. Because I know Ms. Toltzman doesn't want your stuff on the corner. I don't want your stuff on the corner. You don't want your stuff on the corner. Yeah. So I mean, so how long would it take for you to leave that premises? Since we don't have a dispute as to the amount, $3,608. I'm assuming that's past rent on a non-payment.
Correct.
All right. She can give you 10 days statutorily, legally. But if you need more time, we might be able to work with you.
Your Honor, if I could interject quickly,
Okay.
We'd be willing to give until May 19th. That's 20 days from today.
All right. So May 19th. That's beyond the May 9th period. That's 10 more days on top of the May 9th period. And before she can come and actually ask for an eviction from me, so that I would sign a document indicating she can evict. So she's willing to hold off till May 19th.
When 19th to leave the house or to do what?
To leave the house.
We don't want to leave the house.
All right,
We
well,
want-
then May 9th is the date, because May 9th is the 10-day statutory time. You have till May 9th to pay the $3,608 or the money judgment. I'm just wondering, and if you wanted to speak on her behalf, ma'am?
I don't speak English, but I speak French.
That I can't say that I get everything if
Moi, je veux parler.
okay, but if you want to speak with her, you can.
Yes. Je suis réfugié du pays.
Yeah, we're not, as long as she understands what you're saying, we can't, it doesn't transcribe and we don't have an interpreter.
Yes, she translates in English.
And you're not a part, are you a party of the litigation?
Yeah, we live together.
Okay, so she's an occupant of the residence.
Yes.
All right.
But I had children in my children. I don't work in.
Right.
1 month, 1 year to be. I live here, six here for that place, but I don't have the money.
Right.
I'm not working.
And we're not arguing about the money anymore. We're arguing about an appropriate move out date. Okay. Because the money is not in dispute, as according to Miss Land, we're not disputing the money. What we're disputing is we're trying to find enough time so you can leave the place because you can't pay. And because there's there's how many months of back rent are we dealing with?
It's just for 4 months.
4 months. 4 months is 4 months of back rent.
We always pay every month.
Right.
This year we don't have a job.
Right.
That's why we have late to pay payment.
Right. But it's at least 4 months.
It looks like rent is paid through November 30th of 2024. There were payments being made, but a balance continuing.
Okay, so there's still, so we have the 10-day period legally, May 9th. That's what I'm stuck with by law, okay? Unless the other party agrees. The other parties agreed to May 19th. And so that's 10 days past that. Which now we're working with the goodwill of the parties to make sure you're not thrown out of the place, okay? So they can come in and they can say, we want an order of eviction on May 19th. They can come to me, or they can put it, it's entirely up to them. They can come on May 20th or May 21st. When they present the document, I usually sign it within the day or the next day, okay? There are judges that wait a month or a week to sign that. I usually do it within a day or 2 days, just because I don't like to have that thing backed up. Can you be out of the house by May 19th?
C'est sorti à la maison avant le 19 mai. Je veux aller au pico. Je veux seulement chercher le moyen de demander.
They're talking.
Just ask for help to pay for. We just ask.
It's too late in the game to ask for rental assistance at this time.
For the May 19th date, we're fine with paying and staying or vacating.
All right.
So if you can pay the full amount on or before May 19th, then.
So they would extend it 10 days so you could pay or vacate by May 19th.
I don't know what I can say now, because I cannot say yes, I'm going to pay if I cannot pay.
You can, but at least that would seek May 19th would be the date. They couldn't come till May 19th in order to ask me for an eviction notice. So it's 10 days past, almost 10 days past.
But if you cannot start pay by little,
Not at this point.
Not at this point.
Not at this point.
Okay.
Partial payment's not going to be accepted because we're just going to prolong it to go out months. And that's kind of what's gotten you in trouble, is that we've had partial payment all the way along. And then we're here on this date at a formal hearing, and you've got $3,608 of back rent that has not been paid yet. So that becomes problematic. So it might be a time to seek a new place to live that's less expensive concerning this. But I think partial payment's not going to be acceptable at this point.
Okay.
So do you want the May 19th date as the that would mean that Ms. Tolsman cannot come for an order of eviction till after May 19th, which is 10 days past the 10-day period.
That's fine.
All right. All right. So I'm going to indicate for the record that there's no legal issue here based on some of the comments made by the tenant in the matter. No legal issue, and the amount of $3,608.79 are owed for possession. And then money judgment of $3,535.79.
Correct.
And will you be submitting an order to that effect, or do you have an order?
I
to
have
that
an
effect?
order.
All right, let me
Just
see.
had to fill in some dates.
Thank you, Ms. Tolson. All right, so I'm in possession after hearing, and the hearing was really on the day decision to vacate, all right? That we've added 10 days to the 10-day statutory period. So after hearing in docket 25-01368, the plaintiff has a right to recover possession of property. There's now due to the plaintiff for non-payment $3,350, cost of $258.79, for a total of $3,608.79. 4A's checked, and we've extended the 10-day period to May 19th. All right. So and we'll get you can get a copy of this for your records. So what this will indicate is you have to pay or vacate by May 19th, and then they can come and request an order for eviction after May 19th. All right, ma'am. All right. Defendant may be liable for money damages. That's the collateral estoppel language, and the acceptance of partial payment, as we kind of discussed, will not prevent the court from issuing an order of evicting. That's kind of what's been going. I think that's got you in trouble here, is that you made partial payment, and then everything is kind of it's bound to catch up. It's just bound to catch up. There's a money judgment at a prorated amount of $3,535 that I will order for the money judgment. It's a prorated amount through the day. And the May 9th is the 10-day for the appeal period. Miss Lend and any occupants, you understand the nature of the agreement of this, and you're not represented by counsel today. So you understand you have 3 days from today's date to say that something we did here was vague or ambiguous to you. It seems pretty straightforward. It seems May 19th is the date you have to pay or vacate by, okay? But I just so you understand the court rule, you have 3 days to say that you don't understand what we're doing, all right? All right. I will sign the consent judgment accordingly. Did you want, since it is after hearing, but it's just on the time, I'm not going to have the defendant sign it.
Yes.
Because we did have it after hearing. We actually added 10 days to the statutory date.
Yeah.
So for 29. They love it when I make that date mistake. All right, Mr. Len, please keep in contact with your property manager concerning this, but you have to pay or vacate by May 19th, and you can get a copy of the order I just
I
signed.
have a copy of that.
Yes, you can get a copy of this. You can get it from my court officer. All right, ma'am? Okay. All right. Anything else for the record in 25-01368, Ms. Tolson?
No, Your Honor.
Ms. Len, do you have any questions of me?
No, I don't have any question.
All right. You can get a copy of this. Make sure you have a copy for your records. Would she like a copy also as an occupant? So we'll make 2 copies for each any of the occupant, and then we'll sign and scan the original. Thank you for your appearance today, ma'am.
Thank you. Thank you, everybody. Have a good day.
You too. Thank you, Ms. Tolzman. Right, do you have a hearing today, sir?
I did, against Chase.
That is on Case Credit Union, or
Chase Credit.
are you Paul Nichols?
I am he.
Why don't you come up and then we can. This was a discovery hearing. And I don't, oh, here we go. There's Miss Hughes, all right. So that is on my docket. That was, so let me go to my hearings. All right, so we're on the record in docket 1301688. That's Case Credit Union versus Paul Nichols.
Yes.
Will the parties please introduce themselves for the record? Miss Hughes.
Good afternoon, Your Honor. Destiny Hughes on behalf of Case Credit Union.
And sir, you are Paul Nichols, is that correct?
Yes.
All right, thank you. Thank you both of you for being so patient. While we were clearing out some other matters today. I have this set for 2:30 for discovery hearing, Ms. Hughes. Did you want to speak with Mr. Nichols? I can place him on an iPad, and then I could swear him in and you could do some discovery concerning this matter. Would that suffice?
Yes, that would be great, Your Honor. And if I may, so that we don't have to come back into the courtroom once we're done, along with our subpoena, we sent along some requests for documents, and I just need to know if Mr. Nichols has those with him today, or if he is willing to produce them to our office within the next 14 days.
All right, Mr. Nichols, do you have a list of the list of documents that was presented?
I do not have all the documents. I would like to pay the whole thing right now.
Okay, so Mr. Nichols is indicating he can pay the whole thing right now. Did you want to meet with him to negotiate concerning this matter?
Yes, that would be great. Thank you, Your Honor.
All right. And then if we need to, we can come back and put it on the record. I will indicate that at this discovery hearing, I've placed both parties in a breakout room. So Mr. Nichols, if you follow my court officer, we'll put you on an iPad and then you can discuss with Ms. Hughes. Let me make some breakout rooms. Here we go. All right. All right. So Ms. Hughes, I'm going to put you in room 1. You'll get a prompt to go to room 1, and then I'll put Mr. Nichols in the same room. All right.
Thank you, Your Honor.
All right. Thank you. And then we'll come back and put it on the record.
Try it again.
All right, so we're back on the record in 1301688. And Ms. Hughes, you had the opportunity to meet with Mr. Nichols in a breakout room?
Yes, thank you, Your Honor. The defendant indicated that he wants to pay off the entire balance. So if we can adjourn this creditor's exam for 2 weeks to give him time to send the payment to us. If we
All
don't
right.
receive it, we'll just do this all over again.
All right, so let's do the parties met in a breakout room. And we'll set a control date to see that everything's done. If anything's not done, we're still, we've just adjourned this. We'll adjourn it. I would think 30 days would be sufficient, Ms. Hughes. Is that a fair amount of time
Yeah, that sounds great, Your Honor.
make sure the check gets to where it needs to go or what have you? So parties will met in a breakout room and we'll set a control date for.
May 20th at 1:30.
Okay, so we'll set it for May 20th at 1:30 for control date. And then I'll wait to hear from you, Ms. Hughes. If we don't need that hearing, if satisfaction is made concerning Mr. Nichols' debt, you can let us know and we'll take it off, all right?
Okay, will do. Thank you, Your Honor.
All right, so we've set for a control date on May 20th at 1:30. You can get notice from my court officer. Anything else for the record in 1301688, Ms. Hughes?
No, that will be it. Thank you.
Mr. Nichols, do you have any questions of me? You should be all set. Thank you for your appearance today.
Thank you.
Thank you, Ms. Hughes.
Thank you.
Yeah, I got my right one. I had surgery on my right one. I need surgery on my left. But they tell you like they tell you need to get them both done, but you have to forget about one before you start on the other one. So it'll probably be about 9 months before, because the surgery's fine. The recovery is kind of a pain in the butt. It really
I have
is.
an aunt that's had both hips done.
Yeah, joint replacement's it's not easy. Yep.
All right.
All right. Take care, Mr. Nichols.
Thank you, sir.
Valley on Richmond. So this is exactly, I should